I'm just very pleased to be able to welcome all of you and introduce our group's co-founder and leader, Frank Kovacs. Good morning, Frank.
Good morning, everyone. Thank you for joining the Breakfast Club today. The Breakfast Club was formed after 9/11 to help those that lost their jobs to the tragedy. Over the years, due to a myriad of reasons with outsourcing, the financial and economic circumstances of the country, downsizings, the need for the Breakfast Club has continued. We're now over 20 years in with the group, and we try and do our best to, in a pay-it-forward way, help out any of those that are in transition. We have various things you could do. Number one, go to the website, thebreakfastclubnj.com, to join the group. We also will then add you to our email distribution, which is via groups.io. And this way, we limit it to emails that are based to job search or career management, and you would be on that distribution list. In addition to that, we have a Facebook group. We have a LinkedIn group, which you'll normally get an invite to a few days after joining. And again, it's a good way to grow your network. These are people that have been in transition, that have gone through the Breakfast Club program for a period of time, and they're very receptive to helping. So, once you join the group, you still have to connect everyone individually, but just explain that you're attending meetings, you're in transition, and normally the members will connect with you and allow you to grow your network quite quickly. The reason why that's so important is because the number one way to land a job is to have a referral right into the hiring manager. And by increasing the size of your network, the 6 degrees of separation grows, and the probability of being able to do that with an unknown opportunity grows substantially. We have David, who is the Master of Ceremonies today, and Jerry on. They form our presentation group, and they do a lot of work to seek very good speakers and content relevant to both job transition and career management. If you have any suggestions for them, I'm sure they'd welcome them, so feel free to provide any type of suggestions into the two of them. With that, I'm going to turn it over to Jerry Payton. Jerry will do an introduction of our speaker today.
Thank you, Frank. Good morning, everyone. We have an excellent presenter today and a very important topic to cover. We're going to get some facts about employment law, which is not necessarily obvious, but you're going to get your information today. So let me give the introduction there. Attorney Hanan M. Isaacs has 43 years of New Jersey law experience as a mediator, arbitrator, and trial lawyer in the employment law field. As an advocate, he works principally for employees. He is a frequent lecturer, blog and article writer, and multimedia presenter. I'd now like to introduce Hanan.
Good morning, Buccaneers. David, how much is corn these days?
1 year or 2.
I'll tell you that if you don't know. The correct answer is a buccaneer. Actually, the corn is free, which is why I bring it to you in profusion. I want to say a quick hello to Frank Kovacs, my friend. I haven't seen you for a while. And to say that Juliana, your beloved daughter, is the one who introduced me to Breakfast Club. I think my presentation to Breakfast Club was, I think it was 4 years ago. It was so successful that they brought me back for leap year. I also want to show you, this is what's giving me courage today. One of our clients painted this for me. I call that Hanan the Lion, or the Lion-Hearted. And the word lion is in the word client. So We're here today for Essential Employment Law Principles for Workers in Transition. It's my 2023 update. We've added some things to it, but it's a lot shorter than it was a few years ago by many slides because we really wanted to delve into the essential pieces of it. I'm not going to go over everything, just the pieces I think you need to know. And I'm very happy to have David share this slide share with everybody after we're done. David, can you do that? Just say yes.
Yes, and all that you have to do is email it to me a little later, and I will make sure we post it appropriately.
Shelby will mail it to you right now.
Oh, very good. Thank you.
All right. So first slide, vaccine mandates. This is new. We didn't even have that last time I spoke. Basically, the president in 2021 or so, Biden started really pursuing this. A lot of states did. A lot of states didn't, but New Jersey, fortunately, was one that did. The vaccine mandates were blocked by the United States Supreme Court in January of 2022, except for healthcare workers in facilities that receive federal funding. So in other words, there is no company mandate except if a company voluntarily decides to mandate it. And there are fights over, I have a medical issue, I have a religious question. I think the medical trumps the religious. Right after the U.S. Supreme Court blocked the federal mandate, Governor Murphy signed an executive order that requires vaccination for exactly the same group that the U.S. Supreme Court said was coverable, workers in healthcare, congregate settings, which I think is not a temple. It's probably a nursing home, and requiring boosters. So that's still in effect, if anybody wants to know. I have taken the position, I don't love taking cases like this. I refer them. There are lawyers out there who love fighting, tilting at whatever windmill comes along. So if you have this issue, you let me know. I'll tell you where I can get you some help if you need it. All right, so this is a new screen. It has to do with cybersecurity and the fact that cyber criminals can get confidential and sensitive information. So employers have some issues they have to deal with. One is monitoring productivity if they want to without breaching privacy. I have to say that's a very tough thing to do. As an employer, I don't choose to do it. I actually trust my staff when they tell me I came in this time, I left at that time, I did this much work, etc. Other people want to count every stroke. They want to remotely look at what's going on. There are some cases going in each direction. I think it's a terrible thing, but I think that employers, if they do it properly, can mostly do that if they want to implement a program like that. So we have a case we found out. A federal judge said that Cleveland State University violated the Fourth Amendment because it used software to scan a student's bedroom before an exam. I wouldn't do that, but they did, and they got slapped for it. So the question is, will this possibly, not just that case, but others like it, affect the way that employers monitor employees who work from home? It's a big deal because you basically, there's some serious mistrust that's in many workplaces. So you've got employers who are motivated to assure themselves that they're getting their money's worth, that the employees are not knocking off or doing, sleeping or doing another business. So therefore, they put these types of monitor systems in place. On the other hand, you're really going to make the employee population not so happy, and they're going to find a workaround as an employee. So we're just pointing out this is stuff that's up currently. I heard a noise.
Yeah, Hannah, there's actually a middle ground where something like this is required, and that's when the nature of the work requires certain compliance, like payment card industry PCI compliance or HIPAA compliance for healthcare workers. So sometimes the monitoring and having an environment that is quote unquote compliant and having the ability to perform that remotely requires that type of observability.
You know, it's really interesting to me. We had a client a few years ago who was being monitored by 8 cameras, and he still stole from Target. He was a cashier, and he was taking, these plastic, consumer cards. So I don't know. Some people get used to it. They don't care. Others care quite a bit. And quite frankly, the answer to that is think about working elsewhere if that is of concern to you. Next, we have a section here on pay equity. This is a really big deal. To me, it's one of the top topics of the day, not just on this discussion, but across the board. Every employee in New Jersey, as well as federally, should be entitled to equal pay for equal work. People will tell you there's still a wage gap. There's a racial gap in terms of wage. There's a gender gap in terms of wage. There's a racial and gender gap for, let's say, if you're a person of color and a female, you're going to be paid less money than a person of color and a male, and certainly than a Caucasian of either gender. So we have to look at this. Basically, the labor law of the federal government is that salary, overtime, bonuses, life insurance, all the things that you can possibly get, you cannot have inequalities between men and women performing substantially equal jobs. What you have to do is show as an employer that you had a justifiable reason for it, like a union contract, seniority, more experience, more education, whatever the criteria are. As long as it's rational and it's not motivated by things like animus towards a gender or a race. So that's the law. I'm not saying it's being followed. I'm saying this is the standard that the governments have set for people. And New Jersey's been pretty good about that. Continued. You have the right in our state not to be questioned about your salary history. We talk about this all the time. People will say, yeah, but I had to fill out a form. I had to fill out an online questionnaire saying, what are you making now? What were you making? Those questions are illegal. So you're going to say to me, yeah, but I need the work, so I have to fill it out. Okay, well, if that's how you feel, you're going to fill it out. Some people say, illegal question, and go on to the next question. Other people say, if anybody's going to treat workers like that, I ain't working there. Another point, this is very interesting, to deal with inequity, New York City created a law that took effect this year that said when employers send out requests for employment by employees or through recruiters, any advertisement or any marketing has to say what the salary range is. Now, why do they do that, do you suppose? Well, suppose the job requires experience, and somebody comes in and says, I've got the experience, and I'm making $60,000 now, and you didn't tell me the range, and another person comes in and says, I'm qualified, I'm making $100,000 now. Where's the employer going to go? Most likely, they're going to go to the low bidder. So this range thing basically tells the employer and the employee, here's who we're pitching for. If you're not qualified to do these things, please don't bother. But if you are, this is the range we're willing to pay. Will you fit within this range? Yes or no? Now, there are some exceptions. If it's a place that's less than 4 workers, or it's a temporary agency, that's not covered. There was also, because a lot of businesses were upset, they said, let's change the rule to affect only businesses with more than 15 and exempt generic help wanted ads from the range. So the takeaway for these 2 screens, pay inequity is a lingering, terrible problem. And the tools that we're talking about here allow the government to address this problem of the employer keeping things secret because they want to put themselves in the strongest possible position. The game is always weighted toward the house, like in gambling. Same thing. The employer is going to have more weight, but these legislative tools are a way to push back. Now, I wanted you to know that. So, speaking of unlawful interview questions, look at this. You sit down for an interview and they start asking you, are you taking birth control? Are you planning to have a family? Do you have a family? Are you growing the family? Are you married? We prefer stable people with no children but married. How about this one? Criminal record. Have you ever been convicted of a crime? That used to be on every employment application. Now, at least New Jersey, plus Philadelphia, and a couple other jurisdictions say, they call it ban the box. Don't put a box in there to check off, do you or don't you have a criminal history? Because what they require, the state has stepped in and said, we don't like the fact that people with a criminal record can't get employment, even after they're societally rehabilitated. So there are exceptions. Police work, FBI, things like that. They're going to ask you and you're going to tell them. If you lie, you're going to be fired. If you tell the truth, you're probably not going to be hired. But with private sector employment or other government employment, in the first round, and let's say there's three rounds of interviews, first round, second round, they cannot lawfully do a criminal background check. Cannot. If they do and you found out about it, you can sue them. Hard to find out, but maybe you'll find out. In the last round, they can check. And why is that? I know it sounds goofy, but this is the thought. Let the employer fall in love with you first. And then when they find out that you are convicted of arson or axe murdering, they'll say, that's okay because we really want you. Maybe that's an extreme example. But then there's another thing on the screen. So we've got ban the box. What's past the trash? This is a bizarre name to a concept that goes exactly the other way, which is when it comes to education of our children, our vulnerable children, we want to have the custodian, the teacher, the administrator, the principal, the superintendent, not to leave school district 1 having been thrown out because they had some terrible incident with a child or a student less than 18 or whatever the rules are for that district. And then they say, if you leave, we will not pursue you. So then historically, these people would go to District 2, which would say, why did you leave District 1? And you say, because I just didn't like the atmosphere. The culture wasn't what I wanted. But that's not true. So what they now say is, don't pass the trash. And how do they do it? They mandate that the successor district goes back and checks with the earlier district, which is required to truthfully tell them what were the circumstances. So these are all these things: salary history, sexual, gender identity. If you have a tattoo or a hairstyle. I love this gentleman in our picture. Suppose somebody said, you just don't fit the image that we have. And it turns out that all the people who are being categorized there happen to be African American. Or you have a discrete tattoo and they're like, we don't like those. These are discriminatory because it could be that that's a code for a racial or ethnic discriminatory animus, which is illegal. So how do you handle that? So Alex Freund, you're here for a job interview. Do you have a tattoo? My understanding, says Alex, is, let me tell you about the time that I discovered tattoos. No, he's not going to do that. He's going to say, that question, sir or madam. And I know he's only talking to a robot because that's who's interviewing now. But that's an illegal question, Mr. or Ms. Robot. You're not allowed to ask me that. Now, I say that. A lot of people say, but if I do that, I'm not going to get hired. And maybe you're not. And maybe you don't even want to sue them. And if you're 30, 40, 50, even 60, you might not want to go through 4 years of litigation over this type of thing. It'll take you away from lots of life pursuits. Who was the French philosopher who said, I was ruined in life but twice. Once when I lost a lawsuit, once when I won one. So you got to be careful about where you're putting your energy. I tell people, look around the marketplace. If this is not a good place for you, they're asking uncomfortable questions, don't think lawsuit, think other job. Pre-employment inquiries and medical questions. So the Americans with Disabilities Act and the New Jersey equivalent of that says an employer may not ask a job applicant if they have a disability, right? Or if there's an obvious disability, tell me about your leg. You can't do that because it's deemed discriminatory. What you are allowed to do is simply say to every applicant, is there anything that would stop you from performing the essential duties of the position? And if you have an obvious disability, how about this? You want to be a place kicker for the New York Giants, and your kicking leg is, like broken in 3 places. Yeah, they're allowed to ask you about that. How about this? You go in for a bus driver job, and you're going in with a seeing eye dog. And you say, but if you give me an accommodation and let me sit on a real bus driver's lap, I can do just fine. No, the employer doesn't have to do that for you. So it's a push and a pull. You can condition a job offer on certain medical questions or passing a medical exam, but only if all employees are subject to the same thing. So they can't kind of thin out the herd and pick out the one who seems disabled and discriminate. If it's obvious that's happening, you can call me. I probably, in most cases, would refer you to the New Jersey Division on Civil Rights because it's free and you can complain. And if they believe your story and it's corroborated in some fashion, they will go after the employer for you for free. So that's plenty about that. All right, this is a bit of a smorgasbord here, so this doesn't necessarily follow the last thing. You should know for the past 4 years, if you or a loved one needs leave, you now, even if the employer has never done it before, even if the employer doesn't even have a vacation schedule for employees, let alone a full-blown paid time off policy, you now have, congratulations, for full-time work, 6 days of paid leave for medical. Many of you did not even know that until I put that screen up and said this. You get an hour of paid leave for every 30 hours worked for a total of 40, which is a 1,200 max work hours. And you're also allowed to carry over unused time as long as it then becomes your new time for the next year, but you don't get more than 40 hours in any year. So you can carry over, for example, if you have 6 hours or 10 hours from year one, carry it over, and you haven't earned your new hours, you get to use the hours that you carried over. If the employer wants to buy you out and you want to be bought out of that sick leave, they can do that too. Here's a carryover. So I think I just said this. All right, totally other topic. You will often in the workplace be faced with something called a covenant not to compete, and it will be tied to non-solicitation of their employees, as well as their existing customers, as well as a non-disclosure agreement about the terms and conditions of your employment. But the employer is still going to say this is at will for most of us. Few people actually have what I would call a real employment contract that spells out the term, the conditions, probably only cause basis for removal. Most of us, probably 98% plus, are at will. But why does the employer then want these other things? Because they want them. They don't want you taking trade secrets, customer lists, other information, inventions, different things. They don't want you to take their employees. They don't want you to take their customers. So yeah, it's legal for them to do that. They can do that as long as it's reasonable as to amount of time and the geographic region. For example, if you're working at the bodega and they say You're not allowed to be a clerk in any bodega in the world because we're that unique. And by the way, that goes on for 15 years. That ain't enforceable. But I'm going to say if you're in a technical position and it's a year to 2 years and it's New Jersey, unless you're working for IBM, then it's probably the world. And we don't want you stealing employees or customers. Even if you are fired, those will probably follow you. I actually had a case involving IBM where they had all these bells and whistles, and my client said, I got a great new offer from a new company. Does it compete with IBM? Yes. What does the new company say about the covenants that you sign? Because you have to tell them, otherwise the new company is going to get sued, right? Because they're interfering with your old contract. So you tell the new company, they say, this one said, go back to IBM and get a waiver for us. If you do that, it's like Oz and the Wicked Witch. You bring me back the broomstick, we can do business. And I helped them go back, and IBM, of course, created a 15-page waiver, and we brought it back to the new employer. They said, fine. But that's what you have to do. And the non-disclosure agreements, New Jersey, because of, what's the guy's name? The Hollywood guy, the bad Hollywood guy. What's his name?
Weinstein?
Weinstein. The New Jersey created an exception to the non-disclosures for acts of discrimination involving sexual harassment and hostile work environment. So even if you signed one in the past and that's what happened, you're allowed to disclose it. It's kind of like Trump saying to people, all right, I'll waive that for you. This is the state of New Jersey saying it's waived for everyone. It's really interesting how these things happen. All right, this is the heart of the law.
Hanan?
Yes.
So you've talked about some of these, like the illegal questions and other things. What about workers who are 1099 consultants? And for folks, there's a difference between being hired and employed by a consulting company and put on their contract. If you're an independent consultant and you're meeting with a prospective client, are there similar protections?
Shelby, please take a note. Next time in 4 years, I come back to the Breakfast Club. We're going to put one in on independent contractors. Okay, the answer is actually as short as the question. The answer is absolutely covered. Did you know that, David? You did. You dog.
I've signed NDAs, but no one's been so rude to ask me, religion or marital status or anything like that.
Right. Just so you know, the federal law, I'm not going to say that the Title VII covers independent contractors because I doubt it, but I can tell you for sure that this law right here, the New Jersey Law Against Discrimination, not only covers employees, but also independent contractors. So here's a very good example. You're an independent contractor. You come work for Dave Shuckman. Dave is chasing you around the table for whatever reason. I don't know why he does that. And then he says, let's go the other way. Maybe they're just playing a game. And this person is upset about that and says, this is gender discrimination. This is whatever it is. The fact that that person is an independent contractor doesn't matter. You're covered by the law against discrimination. New Jersey has the best, most far-ranging laws when it comes to this of anywhere, including the federal government. The feds, and I'm not talking about federal government for federal employees. Federal government, Title VII, covers all employees in the United States. The only exception is religious institutions. They get a free pass. I don't even want to make jokes about the Catholic Church, but come on, they ought to be covered. Anyway, so this is the heart of it right here. The law against discrimination, Title VII in the federal sector for all employees, except for in religion, Americans with Disabilities Act, and federal and state sexual harassment claims. Look at the wide variety of things that you cannot discriminate against a person based on. race, religion, color, national origin, physical, mental disability, age, nationality, ancestry. Look at this, marital status. They can't discriminate against you if you're single and they prefer marrieds, or you're married and they prefer singles. I've had one case that we actually brought against a bank for marital status discrimination, which was a bizarre case, and it did settle. But more, age, nationality, ancestry, marital status, affectional or sexual orientation, gender identity, liability for military service. And I think there's one missing. It even covers DNA, stuff about, if you have certain strains of this or that, and they find out on some kind of a test, and they're like, oh, this person is liable to get some dread disease, and it's more likely than not based on that profile, that's not permitted either. And I mentioned there is a state Division on Civil Rights that's supposed to enforce this. Sometimes it's good, sometimes it's not so good. There's the federal EEOC that also covers this for the federal causes of action. And then there's courts. New Jersey does not have an exhaustion of administrative remedies. You don't have to go to the Division on Civil Rights to file a lawsuit under Title VII. Take that back. Under the NJLAD. You don't have to satisfy any administrative, I went to the DCR, etc. You can do it, but you don't have to do it. In the feds, if you want to file a federal lawsuit under federal claims, you have to exhaust your remedies under the EEOC.
Oh, excuse me, Hanan. There's a question from Alex Freund, and it has nothing to do with me chasing him around the table. So he's asking, Hanan, terminations are often a surprise. At that time, the employee is asked to sign a legal document summarizing the conditions for receiving benefits. In some cases, the termination benefits are meager and often based on discrimination. At what point should people call an employment attorney?
So, Alex, that's a superb question. And he actually delivered it exactly the way I wrote it. No, I'm kidding. This was Alex. So, I'm going to say this. If you are in a kind of a senior-like position, you've been there 10 years or more, and you're offered a severance agreement that has all the bells and whistles, you always ought to get it reviewed, at least reviewed. And then a lot of times people will go back and negotiate on their own. I will just say, here's 3 things you ought to look at and ask them about. One could be just throw it out there. The employer is also always going to say, you will not defame us. You will say nothing bad about us if asked. But they don't say anything about, what about saying bad stuff about you? Okay, well, how about that? Or you will waive the following 150 statutory causes of action against us because we're giving you 10 weeks of severance. I say, what about putting something in there? You have no claims against the employee, right? There's no reason not to reciprocate in that way. Some will, some don't, but it's certainly worth the ask. If this is something you've worked there for, a year and they're offering you a week of severance, I'll look at it. I don't have a problem with it. I just don't think it's probably going to have the gravity of something where there's been that serious involvement and investment. Think of like you've been tenured at a job for a long. We get people who've been working for 25 years for one company, and they're offered 2 weeks of severance, and there was age discrimination. Yeah, we're going to negotiate that. I just sent off a 6-page letter by certified mail to a big national company because they dinged this lady who did nothing wrong, and they're even fighting over her unemployment benefits. So, you'll know. It's like Justice Potter Stewart said about pornography. I know it when I see it. You'll know. Mental health days. This is Shelby's offering. I think it's wonderful. So in the COVID time, companies began offering days off for people who were going stir crazy, working from home or on site. So question, will employers compensate workers for these days? How many do you get? How many hours per day? In-house counsel, HR, are routinely updating employee handbooks. And every time they do, it's binding on you. If you continue to work there, that's probably sufficient legal consideration. But she turned a corner here and said, hey, the LAD and the Americans with Disabilities call many mental disorders as disabilities. So you're in a protected class, and maybe you need some time off. So what I would do, if you called me or came to me, I'd say, go to your primary care doctor and say, Billy Bob Thornton is suffering from massive overwork and stress. And his mother died of COVID, and his fiance, has long haul symptoms, and this and that. Billy Bob needs some time off. And then it's up to the employer. You're going to pay for it or you're not going to pay for it. Aha! New Jersey has paid sick leave. So we know you could get 40 hours as long as you've worked enough for it. An hour for every 30. So just something to look at. It's a new thought. All right, one of my favorite slides of all. Performance improvement plans. Okay, all those people who have blacked out their screens, raise your hand if you've been subject to a PIP. 1, 2, whoa! Nancy, would you like to talk about it? You'd have to unmute yourself. Go.
Oh yeah. I was. Let's see. How do I even explain it? So I was working for the Federal Reserve Bank, and I was working on a project it was all different Federal Reserve people from all the different banks, and they put me on the plan, and I refused to sign it. So I got pulled off.
What did they do?
I got pulled off the project. And I still had a job because I went back to my area, but I'm sure that, that changed their opinion of me for a long time.
Well, maybe they had passed the trash in that jurisdiction. No, I'm kidding. Terrible, horrible joke. I almost wish I could take that back. But seriously, look at this illustration. We had to search for this. That's the angel of death riding on Hot Wheels with a scythe. In my opinion, that is a PIP. And we get this all the time in high tech, in pharma, in major league occupation. Somebody who's been a rewarded employee for 15, 20 years, all of a sudden their performance reviews with a new manager are dropping like a stone. And you also notice, not in your case, Nancy, because you're not going to be even 50 years old for probably another 20 years, but people over 40, but certainly over 50. Sometimes departments are devoid of anybody who's got like those numbers. And this is how they do it, you see. And it works for them. It's sort of like insurance companies that take premiums and then don't pay out on the claims. They can get away with it because 9.5 out of 10 people, I wonder who that half a person would be, don't complain. But that half a person comes to me. We write nasty, nasty letters that have that guy on the cover, and we say, listen, you're courting with a lawsuit here. You stop this. I also have had the experience, Nancy, and I'm really glad that you volunteered. That was very brave of you. I've had people say, like she did, I refused. I'm not doing that. You're not doing that to me. And do you know what? 2 times out of 3, the employer leaves them alone. They realize if we push this. Now, see, the federal government is a weird body because what happens there, if you make a claim against the department, taxation, whatever, you're making it against the secretary. You cannot sue the underling who got you. They're not liable unless there's a case of, believe it or not, physical assault, up to and including murder and rape. Those people can be personally sued. But anybody else, if it's just merely a horrible employment manager and terrible decisions and getting rid of vast numbers of people, the entire department of that government is going to pay through its appropriation. So it's not great. But in the private sector, people react much more quickly to being told, you only did this. I just did this. We had a whistleblower, like a real whistleblower, who said, in this pharmaceutical company, there's a guy in this division who's faking test results. And the company looked at it and they realized it was correct, that it needed to be fixed. But she personally got dinged because her employer, who's not from this country and is in a different country as her manager, where they don't have these rules, said to her, how could you be so mean to that man? I'm like, you got to be kidding me. His work could have killed people, right? So that's kind of what's at. Now, they tried to put her on a PIP, and she said, you are not putting me on a PIP. And they go, okay. And she ended up transferring. Anyway. All right. Termination of employment.
Oh, excuse me, Hanan. There's a question. This is from Scott. Can an employee require, I'm assuming it's an employer, but it's written as, can an employee require copies of old pay stubs upon offer of a job? And Scott, if you want to unmute and let us know if you mean the employer require it, but
yes, I did.
Okay, so can an employer require copies of old pay stubs upon offer of a job?
How do we know that's really Scott, since he is shielded? But okay, I'll still respond. Scott, if you did work with me, I'd have to see you. So you can, of course, ask. I assume what you're saying is you're in a job, you're leaving a job, you're getting a different job, and you want the first employer to give you copies of pay stubs and other type of indicia of your employment when you leave. I believe the answer is yes. I think you can ask that and require that because it's records. It's records that you need. What if you were being audited and you needed some records? So I've not dealt with that. I've not had to deal with it. When you're in litigation over, let's say, a discrimination type case or some other aspect of wrongful discharge, you can get that in discovery. If you're working for a federal or a state or a local government, you can get that through freedom of information. If you're a private employee, whether it's a for-profit, nonprofit, union, non-union, you're certainly a bit at the mercy of the controller or whoever else is in charge of the records. But I believe push came to shove. For example, you say, hey, Isaacs, get me my records. I think I could do it.
Hey, Hanan,
This is the company that's hiring me. When they offer me the job, they want to see my old company pay stubs for my old company.
Aha, Scott, did you get on this program like 5 minutes ago, or were you here for
Yes.
the salary history?
I was a bit late, yes.
All right, you're forgiven. It's right after Yom Kippur, and I have like a 10-day extension. But that wasn't the point. Did you hear we talked about no salary history is permissible in the interview process?
No, but that's what I thought that New Jersey was a...
No salary history. Now, once you're offered the job, have you been offered the job?
Well, they asked if I'd be able to provide them if I got offered the job.
All right. So once you're offered a job, I believe the statute does say they can ask you for that because obviously they didn't use it to discriminate against you. And at that point, I'm not sure why they need it. Maybe they're trying to check out your salary information as well as your criminal record and a bunch of other stuff.
I think they said something for background check.
Right. It's a background check. And by the way, the companies that do those, which are subcontracting companies, they don't necessarily follow the law. So if you have a question about that, call a lawyer like me. And generally speaking, I'm going to say, as long as they keep it reasonable, and you just got to ask yourself, is their request reasonable? Do they want one pay stub? Do they want a W-2 for the year? Do they want everything going back to Genesis? Maybe it's a bit of overkill. And then do what Nancy Aronson did. Tell them no and see what they do. But they asked you in the conditional. I love that. It's the pluper perfect.
And Hanan,
If
there's
we were
another
to offer you
question.
the job, will you give this to us? And you say, if you were to offer me the job, I'll think about it. We'll see. Okay, let's move on.
Well, Hanan,
So-
there's another question from Joe. And the question is, it may be in your future slides, can you talk a little about the 2019 New Jersey Wage Theft Act?
Shelby, wage theft. Did we cover that? I think we do. I think that's coming up. But I'll just say quickly, basically what this has to do with is employers who conveniently take your work but don't pay you what you're supposed to get. Or they misclassify you as an independent contractor when you don't qualify per the Internal Revenue Service definition, which is that you have more than one client, that you make your own hours, that you bring your own tools or equipment to the employment, like that. How about truck drivers in a fleet of trucks? A fleet of trucks, 2,000 trucks nationally, and all of them are working a 45-hour week, and all of them are using trucks from the company. And yet, amazingly, every single one of them is signed up as an independent contractor. Do you know that these freight hauling companies get fined $25 million for that? That's wage theft, and don't let it happen to you. I have a colleague whose name will go unmentioned who said to me, I will never hire another employee again. They will all be independent contractors. Why? Easier to do the paperwork. You don't have to withhold any tax money. You don't have to give them employment benefits. So you can see why that would be, from an employer point of view, a good thing. Unfortunately, it's also illegal. And they should not be doing that to you. Here's what happens. Dave Schuckman is working for me as an independent contractor. He would never work for me. He'd be afraid I'd take my clothes off. No, Dave Schuckman works for me 40 hours a week, my equipment. I tell him what projects to work on. He has no other customers, right? And he gets injured in my workplace, and he goes for workers' comp, and they go, we've never heard of this person. They don't have a policy, right? Or unemployment benefits. Dave says, I'm your employee. I know you called me a contractor, but I'm your employee. I'm sorry, Dave, says the Department of Labor. That person never paid any money into that system and maybe withheld money from the IRS. This is not good. So just be clear. If you smell something, say something. Don't go along with it because they're like, we really want you, Nancy Aronson, we love you. You're so smiley. It's just that at the end of an 80-hour, 2-week period, we're not going to pay you. And when we do, it's not going to be enough. And if you get hurt, you're on your own. That's called wage theft. Okay. Termination of employment. You're fired. On the other hand, how about if they mistreat you a whole lot and no reasonable person would stay? You can actually be constructively discharged, is what they call it. So discharge status is important because it depends on whether you can get your unemployment benefits. Don't quit unless you can't stand it another second, because you're going to miss out on, potentially, if you've worked long enough for that company, 26 weeks of a maximum $800 a week. That's like $16,000, $17,000. An employment quit means you get no unemployment benefits. It's easier to get a job when you're employed. So I say to people, imagine the employer that you hate that you go in every day despising is actually paying you to find another job. Like, use the time, use the money, and go find something better. Come to the Breakfast Club. Go to all the PSGs in New Jersey. Find other employment. Many people do. The devil that you know could be worse than the one you don't know. So think about that. All right, that's plenty. Unemployment benefits. We already talked about this. There are only a few times that you don't get it. One, if you've conducted yourself in severe misconduct, willful, malicious, deliberately intending to injure the employer, merely being negligent or inadvertent, or it's a performance issue. They wanted you to do it X way, you did it Y way, should not suffice to knock you out of your benefits. Occasionally, if it's a repetitive lateness or a policy friction that you're just not listening, they will ding you. However, this is the trick. Try to get your new employment faster than 26 weeks. But if after 26 weeks you're still not employed and you lost the first 6, then you get the 6 at the end. It's fascinating. Gross misconduct. It's like criminal behavior. If you take a golf club and hit Adrian over the head with it, and then want unemployment benefits, you ain't going to get them. I gave this presentation at PSG in Princeton, and a guy raises his hand and says, I challenge. I think even if you do that, you still get them. And I moved myself away from him. I hope he's not on this call. Okay. Severance agreements. Alex asked about that before. They're by contract. They're not state imposed. There's no legal obligation to offer 1 day of severance. Employers offer benefits by contract, like a real contract, or possibly an employee policy or a handbook. These provisions are legally enforceable. So if they say we're going to offer you a week for every year you worked, and then they say no, we're not, you can sue them for that. So severance agreements will often, not always, include all that range of bells and whistles we looked at before. Give up any claims of damage to you, physical injury, other than workers' comp. That cannot be waived, right? So if you're injured on the job and you can't come back and they offer you employment benefits with a provision that says, I waive all physical claims, it better say, but not workers' comp. Because if it doesn't, it'll be written in by the law anyway. But I would say make them change the language. But they also could include non-compete, non-solicitation, confidentiality, and non-disclosure agreements, subject to the Harvey Weinstein cutouts. Can you see why I get headaches every day? Because I have to know this stuff.
Oh, excuse me, Hanan, there's a question. Oh,
yeah, look at that great picture. And suit and tie.
Yep, with contact information, so thank you. There's a question, I think this is from Alex. Assume you leave because you know that the employer does not meet OSHA standards. Are you entitled to unemployment benefits?
Well, that's a non sequitur. Are you saying that you're leaving because of that? Like, you know there's a problem? Did you report it? Did you threaten to report it? And as far as unemployment benefits, yeah. I mean, nothing's going to affect that unless you clobbered your boss or repeatedly engaged in severe types of misconduct. Short of that, the mere fact that you know of a problem and left is not going to affect you, and they shouldn't retaliate. If they retaliate, you have, Shelby, you didn't put anything in under whistleblower claims. Can you put that in next time?
Yep.
Whistleblower claim. What is that? That you go to your boss, your boss's boss, a liaison, an ombuds, you do an anonymous letter. Our company is sending used plutonium into the local water supply. Love, Anonymous. And they find it's you, Alex, and they fire you. You come see me. We're going to have a talk with those people. Okay? The lady who said to the employer, she told her boss, there's somebody here who's fabricating data for pharmaceutical studies that deal with live human beings. That's a whistleblower. All right? It has to be brought within a pretty short time. It's a year from the time that you were discharged. But those are great cases. If they're provable, you're entitled to damages. You're entitled to reinstatement if you want it. You're entitled to back pay and front pay if you prefer it. And you're entitled to get your lawyer paid for. Why? Because the New Jersey legislature wants workplaces as well as society to be safe. And if something's going on, the first thing you do is you tell the employer, fix this. And if they don't fix it and they fire you because they circle the wagons and shoot out rather than take the charge seriously and fix it, then they're asking to be sued. I actually had this happen, Alex. A guy called me he was a federal contractor, and he said, my job is in jeopardy because I reported something. And I said, did you write them a letter? He says, no, but if I do, they'll fire me for sure. I say, if you don't, you have no case. So I sent him my letter. I wrote him a letter. Dear boss, here's what's going on. And he delivered it. And then he called me from the parking lot where they fired him into. And 3 years later, he got a lot of money. It was all because the letter came timely, and then they fired him. That's what has to happen. The mere fact that you know about something, they're not going to mess with your unemployment. If they do, you can fight unemployment. We take those cases. It's not a lot of money. We'll go argue by phone with the hearing examiner and maybe the lawyer for the employer. And 2 times out of 3, the employee is going to get their benefits. You paid into the system. Why should they withhold it unless you don't qualify? If you qualify, you should get it. Anything else?
Well, there are no other questions in the chat right now, which everyone you're welcome to do. Or, we're not a very big group. As Hanan's wrapping up, you could just unmute yourself and ask a question. Maybe
Don't they
ask
have
a
to
good.
unmute themselves and also put their screens on, David?
I guess if they don't have Pillowhead, they're welcome to do that.
You don't have to do that. That's okay.
Hey, Hanan, I hear very often this employment at will. Does this coin has another side? Is there anything that it's not at will?
I'm going to say 99% of us, when we work for an employer, including an independent contractor for the most part, unless there's a project, we're working at will. It's actually, I have to say, I would argue, in Japan, I don't know if it's still true, but people would go like cradle to grave, one job, 45, 50, 55 years. In this country, that's nuts. You're never going to meet anybody like that. In fact, Alex teaches, because I've taken all of his courses, that people should expect to change jobs every couple of years, or they're not paying attention to their career, right? So, but here's the point. What if the employer could lock you in and say, you're only allowed to leave if we're guilty of cause? And you wanted to leave. How would that be? Slavery was rendered illegal by the 13th Amendment. And by the way, New Jersey did not free the slaves until the 13th Amendment, even after the Civil War. Go think about that.
So one thing I'm observing, Hanan, so you said, to work for so many years in the United States is nuts. So on your LinkedIn profile, you're working the same job for over 40 years. So I guess
what
you're
does
nuts.
That say about me? I'm going to tell you the truth, David. If I could find my boss, I'd quit.
There you go.
I think he works for the worst boss in the world too, probably.
Sounds like he's got fun in the office. That's what's important.
That is really hard. But look, you can see the picture here on the screen. Look at me. My God, what's happened? Time has completely ruined me.
Right. You used to be young and dark hair, and now 40 years later, look what's happened.
Ah, what a cutie. What can I say?
Well,
Anyway,
I suggest we move to a different topic. I know Hanan's boss, and he's just wonderful. So let's move to a different topic.
Very
go
nice.
ahead. Okay. Anybody? Any other thoughts, questions? I never asked you, David. How long are we talking today?
Till about now.
Beautiful. Beautiful.
Yeah, well, what we'll do, if people are satisfied and we've asked all our questions, we will wrap up the meeting in just a few minutes. Also, once we do formally end the meeting, we will, I'll keep the session open for a little while, which is nice. We can hang around and do virtual networking, and that's always fun. If you and Shelby are available, you're welcome to hang around with us for a little while. We kind of miss the one-on-one or the interactions by not being able to be together. So this allows us to do that also a little bit.
Yes.
But
well, if anybody has questions.
Yeah, folks, this is an opportunity to speak with an employment law attorney. If you have specific questions about something maybe recently that's happened to you, or maybe a situation that's coming up due to an anticipated employment, certainly ask Hanan. Otherwise, we'll look to wrap up.
Okay, I'm going to throw something out. The union movement in this country, if you want to know the number one antidote for vast numbers of employee concerns, it's lack of power or a power imbalance. And you could say, yeah, but that changed in COVID because the employers were desperate to get people. Some of them still are. So maybe they'll be more gratuitous or generous to a point. When people are behaving in an illegal way, in discriminating on the basis of age, religion, disability, a lot of that, gender, affectional commitments like that, they're going to do what they're going to do. So the union movement developed as a powerful antidote to very large interests, but it's died mostly in the recent years. The percentage of employees covered right now is less than 10. In the public sectors, federal, state, local, it's more than that, but the average is about 10% across the board. But that is starting to change now. It's interesting. There's a lot of scuttlebutt around the country about unions coming back. And they're coming back very strongly in the hospitality industry and others. And keep your eye on that, because that's where you're going to get. Now, I'll be the first to say, unions can be just as distorted as employers based on their power. And I get calls all the time from union members who say, my union is ignoring me. And I pay my dues and they're not representing me properly. Sometimes we actually get after the unions and we remind them that they have what's called a duty of fair representation of their members. The problem is, to force that, you have to sue the union, and then you're going to sue the employer. That's not going to happen. So, but I'm just pointing out, this is a social movement that's very big, and it's going on in different states across the board. We're hearing things about Amazon and some of these other very big tech companies that are flirting with it, or they get one here and they lose two there. And, but it's just worth keeping an eye on.
Hey,
Something's
happening there. I've got a question about severance agreements. So I remember when I was let go from a company in 2012, I was offered a severance agreement. I thought the dollar amount was fair. I did have an attorney review it, just, to dot my I's and cross my T's. Yeah. And there were certain obligations that I had in the agreement not to speak disparagingly about the company, nothing that I really thought was unreasonable. The attorney's observation was I should make all those requirements of them mutual. In other words, they don't speak disparagingly about me. And so I approached the company and I asked them for that, and they said, no, we don't have control over what everybody in our company would say. And so if you want the money, sign the contract as is. Clearly it was my choice to then accept it, but did I really have firmer ground to stand on?
Two things. I did talk about this. You might have been playing like Candy Crush at that moment.
No, I'm just using a specific example. I don't remember if that was specifically covered in your severance.
Everybody else on the call heard, okay? But it's all right because it's
right after
Untitled, and I'll go back. And it's fine.
Thank you.
The company's response, I always ask to reciprocate. Always. I'm not suing you, you're not suing me. I'm not disparaging you, you're not disparaging me. Now, there are two parts of that. One, it's very simple because your agreement might have actually said this. A lot of them do. When we are called about your candidacy, we will only reveal the following information, and it's going to come out of such and such a position in HR. Do you remember if it said that?
At this point, it was 10 years ago, no, and it's probably in the furthest file in my drawer, so I'm not going to get it.
I'm going to guess, if you look it up, almost all companies will say that. And why do they say that? Because they don't want to talk about you. Because you're going to say, if you didn't get that job, they misspoke about you. So they're like, see, this is like, you know how to pass the trash is a public employer to a public employer? These are private employers, and they don't want to get sued. So they're like, it's not because we like you. It's because we don't want to get sued. So, of course, we're not going to say anything bad about you. But there's one step above that, which would be, and they affirmatively say, we will not disparage you. And Dave raises an employer excuse, which we hear all the time, because we can't control everybody. You know what the good employers do? They say, who are you concerned about, Dave? Is it Alex Freund? Is it Bruce Wentworth? Let's write their names into the deal. And we're going to tell those folks not to disparage you. That a lot of times they will do.
Hanan, I actually did have that written in one of the separation agreements, and people's names went in. The company's attorney kicked against the length of the list, so I had to pare it down.
Joe,
yes,
you had a lot of people not liking you at that company for some reason, and I'm sure it wasn't your fault. I'm sure of it.
It was I didn't trust them.
Okay.
All
right. So here's what you do. You put into the agreement, employee does not trust the following people, and they don't trust him. Everything's good. Anyway, so Dave, I know I was teasing you before. It's okay. I did talk about it, but not in a big way. So your question was completely legit.
And it's funny. So I chose to ignore you this time as well while I looked for my termination letter.
Did you look at your furthest file?
It is well hidden on my computer, but for some reason I have it here. So yeah, I'm not going to go through it right now. But
the only thing you got to look at would be reference, like look up the references or like that. There's going to be a specific paragraph that says, when asked, this is all we will say. Now, whether they're lying, by the way, I'm going to tell you something that you probably don't know. It's pretty important. If somebody calls me for a reference of an employee who gave my name to them and happened to be a horrible employee, I'm going to tell what I know. First of all, they should have called me, and I would have told them, don't do it. They probably have the same bad judgment not calling me as they did as to why I wouldn't give them a good reference. So if Dave Schuckman calls me and says, Alex Freund has just applied to our company. He says that you were an employer of his 3 years ago. What can you tell us about Alex Freund? I'm going to tell him for good or bad. Now, you're going to say to me, you're the employment lawyer. You don't want to get sued if Alex doesn't get the job. Aha. there's a state public policy that allows me to tell my truth. It doesn't have to be your truth. I can tell my truth. I have what's called a qualified immunity. What's the qualification? That I can't misspeak to deprive the guy of a job because of race, creed, color, national origin, whistleblower, or to falsely say something like, I thought Alex was pretty good as a worker, but I noticed that the cash box that was next to his desk was emptied, and I always wondered whether he took it. Alex doesn't get the job. He finds out. And by the way, how do you find out this stuff? This is going to blow your mind. You can hire a company to call the employer and say, hello, this is ABC Company calling on behalf of Carol McCullough, or calling on behalf of a possible employer of Carol McCullough. Can you kindly tell me how she did? And they go, oh, she was the worst, blah, 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 blah. And she's got a contract that says severance. They're not going to say a word. And she doesn't get the job. Carol should come see me because now she has a lawsuit. Right? They broke the contract. They misspoke, or maybe they lied. Right? But how are you going to know that? Because these companies are out there and they will call for you. And it's not very much money. Isn't that wild? Hmm. It's so like I'm not versus spy. Yeah.
I'm not going to send you the my termination letter because it was 10 years ago and I'm not looking for anything. But everything in here seems to be what I'm going to do and nothing that they're going to do. So that's just.
So there's nothing in there about when we're called, here's what we're going to do. Nothing.
Not that I saw. I'm scanning it, but I'm irrevocably and unconditionally agreeing to a lot of stuff that I don't see.
Okay, but I'm going to bring. Thank you for bringing us back to that. This is really important. I say to people, okay, according to my basic math, they're offering you $30,000 to go away. Right. So we asked them to make everything reciprocal. Right. And they said no. Right. Do you want the $30,000?
Right. And that's where that's essentially where I was. So
do you want the privilege of maybe suing them and maybe losing and going through a whole lot of wasted time? Whereas you could say, as an extension of, I'm working here looking for other work. Now I'm not working here and they're paying me to look for other work. And by the way, I have to bring up another thing. This non-compete stuff, the legislature in New Jersey was looking at a bill. I don't know what happened to it, where if they were going to make you sit out for a year and a half, they had to pay you to sit out. So if you got a job offer from a great company, but you couldn't take it because they were sitting on you, you would get paid for that. There's one company in New Jersey that I know of. I'm sure there are others. Firminish has a provision that when we terminate you and there's a severance agreement, we have the right to impose this non-compete with these terms of year and a half, whatever, but only if we choose to do it. Maybe we'll leave you alone. So we have to talk about that after the fact. But if they do it, they say, we will pay you for up to X period of time, the period that's in the non-compete. Isn't that progressive and amazing? That's how it should be. Why should the employer force you to sit out and you can't pay your mortgage? So this is something to look for.
One thing I have in an agreement with actually Allied Signal, now Honeywell, if I come down with a strange disease, they could be on the hook. And I actually do know I know one person directly, and he told me about a guard there. Both of them came down with the same strange cancer. Hopefully I never exercise that part of the agreement.
That is progressive. A little bit, certainly falls into the better than nothing.
Well, I was afraid of the chemicals because it's the old Bendix plant in Teterboro where Walmart and Costco are now, and I believe it was a Superfund site or close to it.
I think what they should do with Superfund is just designate the parts of New Jersey that are not Superfund, and everything else is. The default should be Superfund. It's just my opinion.
There's a question in the chat, so I'll read this on behalf of Juliet. What is a reasonable clause and time frame you can request in your hiring contract asking for severance upfront if they lay you off for any reason other than performance? 6 months, 1 year. Do you have standard language for this that you can share?
I do not have standard language. I know I've had clients who negotiated this, but it's not that hard to put together. And by the way, don't make performance an exception. What you should do is make like moral turpitude or criminal behavior. For all other reason, you want your severance. Now that's going to be a real contract. I say real. Employee contract, employee handbooks, policies of the employer. They're what we call a quasi contract. It's like margarine. It's kind of like butter. But if you want butter, you got to write it up in a way that says, here's the term, here's the dollars, here's the benefits, here's the termination provisions. Just put it all in there. It's really it's an employment agreement. And if they still want to say it's at will, you can still create something that says that. It's like an offer letter, but it would have that additional information, and everybody signs it, and you scan it and put it in Dave's last drawer and keep it for a rainy day. Let's put it this way. It's good if you can get it. Most people cannot get that. If you're in a place of your work career that gives you that ability, go for it. It's sort of like, professional ball players. Hey, I'm going to get paid whether or not, if I'm injured, I'm getting paid for my season. It's all a matter of your negotiating power.
Yeah, no, thank you, Hanan, for that input. No, I just think it's interesting, and depending on, you're right, where you are in your career and your level and all that, I think it's something that it's very reasonable to put forth in your negotiation. I just don't know if that's really common nowadays. I know it was common, 8-10 years ago, but I wasn't sure if that's common now, or how is that viewed? Is it reasonable to ask for 6 months or 1 year? In the past it used to be a year. So I just kind of wanted to, ask you or even Alex of what your thoughts are about that.
Yeah. Well, I don't see that very often, so I'm going to say I would find that to be an uncommon element. But if you're going to negotiate, go for the highest number that passes the smell test, because they can always cut it back. They cut it back to zero. They cut back to zero.
Juliet, my opinion is you should go and ask Hanan.
I'm sorry?
He wants you to ask me.
My opinion is go and ask Hanan.
I'm sorry, Alex. Can you repeat that?
He wants you to ask me. Did you hear me?
Yes, Hanan.
Yeah, Julia, you had asked for Alex and Hanan's opinion, and Alex said his opinion is to ask Hanan.
Gotcha. Okay.
Alex.
Anyway, folks, there are no more questions in the chat, so in just a moment we'll wrap up the meeting. But we're going to stay online, and you're welcome to hang around with us. I will stop the recording when we hang around online. But Hanan, I want to thank you so much, as always, for giving of your time and expertise and experience to us. And we also appreciate Shelby helping with creating such a wonderful program. Thank you very much. With dedication of folks like you, it helps make the Breakfast Club more valuable to members here that are participating. So thank you. And for folks, yeah.
I'm sorry, not Alex. David. So I'll probably see everybody this program for 2026. So I'm thinking.
Yeah.
Not before.
Yeah. Right. When let me know your retirement plans. We'll book you right before then, and maybe when you get to 45 years and you're even working longer.
Exactly. Well, it'll be more than 45. It'll be 47.
There you go. Yeah, but of course, we'll have you back, and I know you are also active with other groups as well, which is certainly very nice. And you did post your slide for contact information. I did put that in the chat as well, so folks, you can get that. It's Kingston Law Group, and you can contact Hanan if you need. And also, next month, we'll be right back here virtually again. We will be November 12th at 8 o'clock in the morning. And Bill LaChance will be presenting. And he may be presenting also with one of his partners. We're going to get a little clarity. But Bill will be here, as he is about that time every year. Key financial planning considerations for those in a career transition. Always wonderful to have Bill join us, because not just that he's a financial planner, but he doesn't talk about traditional wealth management and funding type stuff. He really talks about things, budget planning, planning for college, expense oriented things that are really important for job seekers. So it's not a salesman pitch at all. It's really very common sense financial planning. So you're welcome to join us then. So that's who will be with us next month, November 12th, 2022. So with that, we'll say thank you very much, everyone, for joining us on the recorded version of the call. We look forward to seeing you virtually next month. And let's get on with the hanging around the virtual meeting room. So thank you, everybody. Bye.